Welcome back to the deep dive. Today we are jumping into a really high stakes and time sensitive topic, UK visa curtailment.
Right. We're going to be looking at that mandatory 60-day decision window for skilled workers.
And that includes people in the care sector, which is huge right now, and of course their dependents.
Exactly. And this deep dive is, well, it's necessary because the rules here are so rigid. The source material we're using navigating the 60 days really cuts through the misinformation.
So our mission today is to distill those critical timelines, the legal risks, and the strategic options so you can move from, that feeling of anxiety to actually taking informed action.
And we have to start with the most foundational truth in this guide, the one thing you have to get right from the very beginning.
Okay, let's hit it. What's the core insight?
The source material stresses, and I mean stresses, that this 60-day period is not a grace period.
Right. It's legally defined as a decision window.
And that distinction is just absolutely crucial. A grace period suggests, some leniency, time to wait for something to happen.
But a decision window sounds like you're on the clock.
You are. It means you are legally obligated to take decisive action. That's either submitting a valid new application or physically leaving the country.
And if you don't?
If you fail to act, you risk losing your legal status entirely, which has just devastating consequences for your future.
Okay, let's unpack this. Let's really nail down the timing because this is where the first mistakes happen. When does that countdown actually begin?
It starts ticking from the date the Home Office curtailment letter is issued.
So importantly, it does not start the day you stopped working.
No. And we see confusion on this all the time. There can be a gap, sometimes weeks, between your last day of employment and the Home Office getting around to sending that official letter.
And what about the math itself? Let's say I've got 6 months left on my visa and then the letter arrives. What happens?
So the guide clarifies this rule pretty simply. If the remainder of your original visa is more than 60 days, it is curtailed or shortened to exactly 60 days.
But what if it's less? Say I only had 45 days left anyway.
Then the original end date stands. The rule only shortens the time. It never extends it.
Okay, this is where it gets genuinely frightening, based on the source.
Yeah.
The hidden danger of communication.
Yes.
You're expecting this formal notice, but the Home Office sends the letter by email, and it goes straight to your spam folder.
Or you moved 3 months ago and you never updated your address with UKVI.
And the clock is still ticking.
It is. This is a silent killer of integration status. Legally, you are considered to have been informed, even if you never physically saw the letter.
So what's the takeaway there?
Check your email, including your junk folder and your physical post, every single day from the moment your job situation changes. It is non-negotiable.
So the clock has started. The most urgent, practical question for anyone listening has to be about money. Can I work? While I'm desperately looking for a new sponsor in these 60 days, can I take another job just to pay my rent?
Look, the blunt answer from the source material is almost always no. Your right to work was tied specifically to your previous sponsor. Until a new visa application is fully approved, those conditions generally stay in place.
But wait a second. If I file a new application before the 60 days are up, I get something called Section 3C leave.
You do.
And doesn't that mean I'm legally allowed to be here? So what is 3C leave and why doesn't it let me work?
That's a great question, and it's probably the biggest area of confusion.
Yeah.
Section 3C leave is a critical piece of protection.
Protection from what?
It protects you from becoming an overstayer. It means if you submit a valid, in-time application, you remain lawfully present while the Home Office processes it.
Okay, so lawfully present, but you're saying that doesn't mean permission to work.
Exactly. The justification is that your work permission is tied to specific visa conditions. The 3C leave is just an administrative bridge to maintain your legal status.
So the bottom line is,
You cannot start working for a new employer until that new visa is formally approved and issued. Not just submitted, approved.
and doing so is a breach of your conditions, which leads to the really serious warning in our guide.
It does. The consequences are severe.
They can track you, right?
Yes.
Yeah.
The Home Office uses HMRC monitoring. They cross-reference tax records, national insurance contributions. If they find you working for a new employer before approval, they will flag it.
And the consequence for that specific breach?
It can be a mandatory 10-year ban from entering the UK. It is the definition of high stakes.
Wow. That puts an immense amount of pressure on you. You can't work, you've only got 60 days. So let's look at the first path in the sources. Option 1, finding a new sponsor.
This is the most common route, the most logical one. But the guide calls it the hardest to execute. under that time pressure.
Why so difficult? I mean, if I have a great CV, isn't a job offer enough?
A job offer is, frankly, nothing without the legal infrastructure behind it.
Okay, so what's the first step?
First, you have to ensure the company is on the 2025 Register of Licensed Sponsors. A lot of companies aren't.
And second,
And this is the most important part. You need the Certificate of Sponsorship, the COS.
the COS.
It's a unique reference number. It's the proof that the employer has reserved a visa slot for you. A verbal promise from a hiring manager is legally meaningless. You need that number.
And this is what the guide calls the time trap. Why?
Because getting a COS takes time. Even in the best-case scenario, the source says it often takes employers 3 to 4 weeks.
3 to 4 weeks.
Yes, to do their own HR, their admin, then apply to the Home Office for the COS.
So if you start your sponsor search on day 40 of your 60-day window,
The math just doesn't work.
you're almost certainly too late. By the time they issue the COS, your 60 days are up. You need to be interviewing the moment you get that curtailment letter.
So if sponsorship is looking impossible, option 2 is switching categories, specifically to a partner visa.
And this has become so much more complex with all the rule changes in 2024 and 2025.
What's the biggest change?
Well, what's interesting is the shift in emphasis. It's not strictly about proving you've lived together for 2 years anymore. Oh, I thought that was the main rule.
It's a common misunderstanding. The requirement now is to prove a genuine and subsisting relationship for at least 2 years.
So if we haven't lived together, how on earth do you prove that? What does heavy proof actually look like?
It's got to be more than just photos and text messages. They're looking for things like shared financial responsibilities, joint bank accounts, a mortgage, a really comprehensive travel history together.
And a good reason for not living together.
A very good reason, yes. The burden of proof is high, and the application has to be perfectly documented.
And then there's the big one, the financial hurdle.
Correct. Your partner now usually has to earn at least the new minimum income requirement. Right now, that's sitting at £29,000 a year.
And that's not something you can just fix overnight.
No, it's tested with official documents over a set period. The money has to have been there already.
Now, you flagged this next point as one of the most important takeaways in the entire source. If you manage to switch from a skilled worker visa to a partner visa, there's a settlement reset.
Yes. This is a crucial point for anyone's long-term planning.
What does that mean, a settlement reset?
When you were on the skilled worker route, you were on a 5-year path to indefinite leave to remain, or ILR, settlement.
Right.
Switching to a partner visa resets that 5-year clock completely to zero.
To zero. So even if you were 4 years in,
All gone. You start again from day one on a new 5-year route.
that is an incredibly heavy trade-off. You've avoided being removed from the country, but you've lost years of progress.
It's a profound trade-off. You have to weigh the immediate security of staying against restarting a multi-year journey. That means another 5 years of visa fees, health surcharges, and uncertainty.
Let's connect this to the bigger picture. It's not just about the main applicant, is it? What about dependents?
Their risk is immediate and absolute. A dependent's visa is legally tied to the lead sponsor's visa.
So if the primary skilled worker's visa gets curtailed,
So dependent's visa is curtailed too. Their 60-day clock starts at the exact same time.
and what if the relationship itself breaks down during that period?
The dependent must tell the Home Office. But the guide does highlight one really critical exception here.
Okay.
If a dependent is leaving the relationship because of domestic abuse, they might be eligible for something called the Domestic Violence Concession, the DDV.
And what does that do?
It allows them to apply for settlement on their own, independently of their partner's status. It's a vital protection.
But for everyone else, the advice is to be proactive.
Yes. Dependents should start immediately looking for their own route to stay. Find their own sponsorship, perhaps, to secure their future on their own merit.
Okay. Now we get to the final options. And you're contrasting a really desperate tactic with the safest route out. Let's talk about the fee waiver trap.
Right. This is a dangerous strategy. The danger starts because fee waivers are explicitly not available for visas like the skilled worker or health and care visa.
But people try anyway.
Some do. They try to apply for a human rights fee waiver, not because they actually qualify, but purely to game the system.
To what end? What are they trying to achieve?
They're trying to trigger Section 3C leave. Submitting pretty much any valid application or waiver request grants that 3C protection, which buys them a few extra months while the waiver is processed.
Or just buying time.
That's all it is. And this is where it gets really interesting, because the source says UKVI is getting very aggressive about this.
So?
They are actively contesting what they see as meritless applications. And the source warns, if the Home Office refuses your fee waiver and decides you only filed it to buy time, if they call it frivolous,
Then what happens?
they can cancel your 3C protection retroactively.
Retroactively. What does that mean in practice?
It means if you filed the waiver on day 59 and it's refused 3 months later, you are suddenly an illegal overstayer going all the way back to your original visa end date.
So you've been an overstayer for 90 days without even knowing it.
Exactly. And that tactic, that gamble, risks a 10-year ban for deception. It is an unbelievably high-risk move.
Which brings us to the final and maybe the wisest option, leaving the UK safely. Why is this sometimes the best strategy?
Because it's about protecting your long-term immigration future. Leaving within the 60-day window means you have complied with the law.
Your record stays clean.
Your record stays clean. And a clean record is priceless. It is so much easier to apply for a new visa in the future if your history shows you follow the rules.
Compared to the alternative.
The alternative. Overstaying for more than 30 days is a mandatory 1-year re-entry ban. Deportation can trigger a 10-year ban. Leaving safely avoids all of that.
This has been so heavy, so let's distill this down. The one rule to remember from the guide is crucial. Do not guess, do not hope, only act on facts.
And we can boil that down to 4 essential points. First, check your email and post daily for that curtailment letter. That's when the clock starts.
Second, verify any potential sponsor yourself on the government's official register. A promise from a manager is not a COS number.
Third, if you're switching visa categories, like to the partner route, you must assume the settlement reset will happen. Be prepared for that 5-year clock to start all over again.
And finally, avoid those desperate time-buying tactics. That fake fee waiver isn't worth the risk of a 10-year ban.
You know, the source material really forces a tough choice on anyone facing this. In 60 days, you either get a new visa or you leave. The choice between, say, a risky application that could get you a 10-year ban or protecting your clean record by leaving. It's a choice between immediate risk and long-term viability.
And that leaves us with a final provocative thought.
It does. It raises an important question for you to consider. What value do you place on an unblemished immigration record for the rest of your life, not just for the UK, but globally?
Knowledge is power, especially when the clock is ticking. Use what we've unpacked today to make sure your next move is based on fact, not on hope. We'll see you on the next deep dive.